An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Barron v. Baltimore, 1833. After the proposed federal constitution was submitted to the states in 1787, many states ratified it on the condition that certain amendments would be added. In 1789, the first Congress introduced 12 proposed amendments, 10 of which were ratified at that time. Today, these 10 amendments are known collectively as the Bill of Rights. Study Guide. The first 8 amendments to the Constitution put limits on the powers of the federal government. Do they also limit the powers of the state governments? For example, the First Amendment begins, Congress shall make no law respecting an establishment of religion. There is no question that this provision limits Congress's powers. But what about the Fifth Amendment's Takings Clause? It provides, nor shall private property be taken for public use without just compensation. The amendment does not specify whether the state governments are also prohibited from taking private property without just compensation. Barron versus City of Baltimore would resolve this question. John Barron owned a profitable wharf in Baltimore Harbor. During street construction, the City of Baltimore diverted the flow of streams, which created mounds of sand and earth near his wharf. As a result, the water became too shallow for most vessels to dock. Barron sued the mayor of Baltimore for damages. He claimed that the city's actions constituted a taking of private property for public use without just compensation under the Fifth Amendment. Chief Justice Marshall's majority opinion rejected Barron's claim because he concluded that the Bill of Rights limited only federal power and did not put limits on the power of the states. Marshall's analysis is based on inferences from the Constitution's text. For example, Article 1, Section 9 provides that, quote, no bill of attainder or ex post facto law should be passed by Congress. This provision appears in a section that applies exclusively to Congress. In contrast, Article 1, Section 10 provides that, quote, no state shall pass any bill of attainder or ex post facto law. This provision appears in a section that applies exclusively to the states. When the framers sought to restrict state power, he reasoned they did so expressly. Marshall added that if states wanted to provide additional safeguards to liberty, then the remedy was in their own hands. That is, they could have amended their own state constitution. This process was far easier than amending the federal constitution. Finally, Marshall also makes a historical claim that the Bill of Rights was aimed at assuaging anti-federalist concerns about the new national government and its powers. However, quote, these amendments contain no expression indicating an intention to apply them to the state governments. Chief Justice Marshall's reasoning in Barron came to be the settled view of how and why the rights in the first 10 amendments did not apply to the states. However, this view would change with the ratification of the 14th Amendment. Indeed, the 39th Congress drafted the 14th Amendment in part to reverse the court's decision in Barron. After an initial resistance by the Supreme Court, all but a couple provisions in the Bill of Rights have now been extended to the states by incorporating them into the Due Process Clause of the 14th Amendment.